Hey, welcome everyone. Welcome to OurSeniors.net and OurSeniors.net magazine. Here we are with an episode that everybody should be interested in listening to. We have the honor and privilege of interviewing someone who's an approved vendor and has been part of the team. And this is something that is extremely important for seniors, especially those of us who have family members. We need to prepare for our future, everything that goes on behind the scenes, okay? So without further ado, I'd like to introduce Mrs. Wendy Mara. Welcome, Wendy.
Thank you, Julian. I appreciate your having me on the radio show.
All righty. Well, tell us a little bit about Wendy Mara and the law firm, your background, the whole 9 yards, if you don't mind.
Sure, no problem. I am originally from Massachusetts and moved down here to Florida a little over 30 years ago. I went to Daytona State, which was DVCC then, and did 2 years there, and then transferred over to Stetson, where I earned a degree in English. I graduated, and that was in '93, and I taught in Volusia County Schools for a couple of years, transferred over to Father Lopez. I taught at Father Lopez High School for 10 years, so for a total of 13 years, I was a high school teacher. While I was teaching, I attended University of Central Florida and earned my MBA. And then from there, I went to Florida Coastal School of Law and earned my law degree. And I've been practicing now for going on 10 years, going on 11 years. I am married to Robert Mara, who works at Holland Financial and has actually been a guest on radio programs talking about financial matters. I have 6 children, ranging in age from 7 years old to 35 years old, and 3 grandchildren. So my life is very busy.
Wow, congratulations, especially with 3 grandchildren. I have 2 myself, and they can be a blessing and keep you busy, to say the least. So sounds like you're staying busy for sure.
I am. Can't complain.
Wow, that's excellent. And Wendy, we've known you, and the fact that you have had a location here in Ormond Beach, Volusia County, but tell us, where else do you have offices where clients can actually set up appointments with you, et cetera?
We have an office in DeLand, right on the main drag there at the DeLand Executive Center and Woodland Boulevard. And then we have an office in Palm Coast on Palm Coast Parkway. So I typically go to DeLand 1 day a week. I go to Palm Coast 1 day a week. And then I'm in Ormond the other days. And we're pretty flexible. If somebody really needs to see me on a certain day, we can change things around. Currently, we're having all of our appointments by phone. But even before we had COVID-19, it was not unusual for me to have phone appointments because I do have clients that are from across the country and even have had some clients in other countries. So it's not unusual for me to conduct business by phone. And there are many clients that I've never met in person. I've conducted all of my business through phone and email. So this has just extended that a bit with all of my clients at this point. We're having phone consultations.
Excellent. That is excellent. And with everything going on, obviously that's a major advantage to be able to handle things like that, especially when emergencies come up, et cetera. And so Wendy has an MBA. With that MBA and, your pursuit and degree and Juris Doctorate, what is your specialty, Wendy? What do you focus on and what services do you provide?
Well, I think that the name that we go by tells it all. It's Mara Law Elder and Family Law Center. So I would say the majority of my business is more elder law than family law at this point. So probably about 30% of my business is family law. The other is elder law. And part of the elder law, the estate planning, we also do a lot of business types of transactions with creating businesses and establishing those businesses. But with both of those types of practices, you're dealing with families and you're dealing with all of the dynamics that go with that. And what we focus on is protecting individuals, their families, and their assets, whether that's in family law, guardianship, probate, estate planning, business creation of businesses. That's what we focus on, is protecting individuals, their families, and their assets.
Excellent, excellent. And give us an example as to what documents do individuals need, generally speaking, to protect themselves and protect their assets?
Well, the first thing that comes to most people's mind when they think of estate planning is they're thinking of wills. And those are very important documents. What a will do is allow the courts to know what the intent of an individual was as far as how assets should be distributed. Many people are under the misconception that is, if you have a will, you do not have to probate your estate, and that is not true. A will only gives direction to the court and to the person who's appointed, the personal representative, how those assets are to be distributed, but it does still need to go through probate. If somebody is wanting to avoid probate, then that individual needs to be looking at creating a trust and making sure that all of the assets that you have are titled in the name of the trust. For most people, the biggest asset that most people have is their home. And so if all you have is your home and individual financial accounts, instead of creating a trust, you could make sure that all of your financial accounts have named beneficiaries. And your home, you can do what's called a ladybird deed. And there are not very many states that allow for this type of deed. But what a ladybird deed does is it allows you, it's like having a beneficiary on a bank account. It allows you to name individuals who will become the owners of your property when you pass away. But it still allows you, as the life estate holder, to, if you wanted to, mortgage the property, sell the property. You can change the beneficiary. So you still have control. But upon your death, you've chosen who you want to get your property. So that's, one of the other documents if you're trying to avoid probate. So those are dealing with your assets upon your death. What I usually tell clients is of course, you want to take care of those assets, but one of the things that I'm most concerned about is what's going to happen while you are still alive if you were to lose capacity. And, that's a whole different conversation.
Okay. So let me make sure something interesting that you mentioned there, to make sure, especially if you're married, to have a beneficiary listed in all your bank accounts, business accounts, you name it. If you do have a will, the simple version, that automatically you have to go through probate. So what happens? The spouse expires, you begin the whole probate process, which we'll get into in a moment here. But in the meantime, if they're listed as a beneficiary, things continue and they still have control over the accounts, correct?
That is correct. And more often than not, when one of the spouses passes away, there typically doesn't need to be a probate if the couple are owning all of the property together as husband and wife, and they own the home as husband and wife. Automatically the other spouse becomes the owner or continues to own the property or the financial accounts. So it's often what we're seeing is there's a probate once the second spouse has passed. and then there needs to be a probate of those assets. And if you've done your work up front and made sure that all of your financial assets have named beneficiaries, and if you've done a ladybird deed for your property, or if it's in a trust, then you shouldn't have to do a probate. And for some people, that's a very important goal. They don't want their families to have to worry about doing a probate. However, there are times that it's not a good idea to have a beneficiary named on an account. So if you have a beneficiary that is disabled and receiving SSI and Medicaid, if they were to become the beneficiary of an account, essentially they'd lose their benefits. So there are times that it's not the best idea to have named beneficiaries, and maybe you want to come up with some other strategies for that particular beneficiary. If you have a beneficiary who has addiction problems, or a beneficiary who has spending problems, you probably don't want to be having them receive an outright inheritance. You probably in those situations want to do some other types of planning, like a trust. So it depends on, again, the family dynamics and who the beneficiaries are.
Okay. And so technically, it probably gets more complicated than this, but if we understood you correctly, if the spouse is listed, they're not, signed up for SSI benefits or anything, and all of a sudden the spouse unexpectedly passes away, and the surviving spouse is the beneficiary, you still have to go through probate, but it's a pretty easy process. Is that correct?
Well, if all of the accounts had named beneficiaries, then there does not need to be a probate. So the only time that there would need to be a probate is if an account was found, and it happens, where the individual just forgot to put a named beneficiary. And so then it ends up going to the estate, and a probate needs to be done. So I always encourage people, even if you think you have named beneficiaries on your accounts, check. Get documentation, make sure that you actually do, because otherwise those particular assets will need to be probated.
Okay. And, we don't want to get into all the terms, but in the past, people have used tenants in common or TOD. Can that make a big difference? What terminology is used there?
It really can. So, when you're titling property, a married couple is tenants in the entirety. So both of you own it 100%, which sort of sounds an odd way of putting it, but either one of you have complete access to the accounts. One of you dies, the other one gets it. A tenants in common is where both of you are owning percentages. And if it doesn't indicate, then it would be 50-50 unless it actually indicates particular percentages. But upon that other person's death, you don't necessarily, you don't get that money or that property 100%. It's not automatically yours unless it's joint tenants with rights of survivorship. There's some sort of language in there to indicate that, you become the owner upon the other person's death. So that can create issues upon the death of the person, but it also can create issues if you have two people who are, owning property and one decides that they want to sell. So there's a variety of issues that can arise from that. But for the two types of property ownership that is going to allow the other person to own it upon the death of one of the parties is either tenants with rights of survivorship, or the tenants in the entirety if you're a husband and wife.
Okay, excellent. And obviously it can become very tricky. So this is why, and I guess every state runs things a little differently. So it is extremely important for people relocating to Florida or being a snowbird in Florida that if they end up moving permanently to Florida, that they handle things and they take care of things properly. But at the same time, Wendy, correct me if I'm wrong, even if everything is titled correctly, anybody in the family, anyone who may be a creditor, et cetera, they can challenge it and they can go and take it to request probate, right?
Right, and there are people who've objected to a transfer of property, or have argued that beneficiary designations were done with some fraudulent intent. So, I mean, there's always those types of arguments that can be made. But with a probate, when a probate is filed, all the interested parties need to be noticed. In other court cases, they need to be served with a sheriff or process server. In probate, people are in Florida. Probate people are served via the U.S. Certified mail return receipt requested. So you have the signed receipt, but it's not actually somebody physically bringing a document and knocking on somebody's door like you see in TV. So it's a little bit different with probate matters, how people are served, but everybody should have the opportunity to object to how things are distributed. But that's if there's a will. If you have direct beneficiaries for everybody, there is no probate. So then they'd have to open up, a suit on their own to argue that there was some fraudulent intent or something was going on, fraud in the inducement, elderly exploitation. I mean, whatever, argument they're going to make, they would have to make it. So it's a little bit different. With a probate, you're noticed. So you have the opportunity, that something's going on, that there's a court case where with a direct beneficiary, you may not even know that there was an asset there. Nobody's going to notify you because you're not the direct beneficiary.
Okay. And with respect to the example that we were referring to earlier, one of the spouses passes away. It's all tenants in the entirety. Everything continues. But what happens based on, obtaining the death certificate, et cetera, et cetera? Do they still need to go through like a small version of probate where they just get, the green light, or how does that work?
No, they don't need to do anything. Some, I've seen some situations where people, the spouse who remains behind wants to have the property in his or her name and can file a death certificate with the clerk of court. And then, that it makes it clear that the property is owned by just that one spouse. However, it's not uncommon for the husband to pass away before the wife. And there's many women who don't want to have the property showing in their name alone, because then there's public record that they live by themselves, and they don't want that out there. So it's not uncommon for people to just not do anything upon the death of one of the spouses. And you really don't have to do anything at that point.
Okay, excellent. And even if the house is being financed and has a mortgage, can they still proceed and file the Ladybird deed that you're referring to?
Yes, you don't need the mortgage company's permission to file, to record a Ladybird deed. However, because the Ladybird deeds are not common in other states, sometimes when somebody decides they want to refinance their home, if they're using a national bank or national lender, sometimes they just don't understand how a Ladybird deed works and don't feel really comfortable about that. So there have been some instances where we've had to transfer it from a Ladybird deed back to a regular deed if they're selling or mortgaging. And then we can just go ahead and once they get their whatever financing they're doing or buying a new house, just go ahead and transfer back into a Ladybird deed. That shouldn't have to happen because in Florida, the law is very clear that a Ladybird deed is acceptable. But, sometimes when you're dealing with national financial institutions, they're looking at not what's law, particular in Florida, but they're looking at what's common throughout the United States.
Okay. So even though the mortgage and whatever is recorded through the clerk may say tenants and in the entireties, it's still a good idea for them to do the ladybird because the mortgage can be sold from one institution to another, and you want to make sure that the record is clear, correct?
Yeah, we've never had an issue with mortgage companies when we've done labor deeds. We've just never had a problem with that. It's just the same with when we transfer property from individuals into their trust. The mortgage company, as long as they're getting paid, and the individuals are still personally responsible for that, for paying of the mortgage. So we haven't had any problems with that.
Excellent, excellent. Now, you were referring to earlier how to avoid probate, and you mentioned trust. Give us a little insight as to what is the difference between a trust and a will.
Well, the first big thing is that when you have assets held in a trust and they're held in the name of the trustee, those assets do not need to go through probate. The trustee has the legal ability to transfer property, to sell property, and of course it's all dependent upon what the trust documents allow. But the whole purpose is so that the estate does not have to go through probate. So the trustee is given quite a bit of power to be able to sell assets, distribute assets to the beneficiaries. If you do have a beneficiary who is a minor or has special needs or spending problems, you can empower the trustee to continue the trust for the benefit of those individuals and pay out as those individuals actually need funds. So a trust can be really handy if you have different types of beneficiaries. And in particular, beneficiaries, like I said, who are disabled, spending problems, or minor children. Trusts are very helpful for that. I also recommend trusts when people own property in other states, because a probate will only handle real property that is in the state in which the person resides. So if I have an individual who lives in Florida and they have a homestead in Florida and other assets, we do a probate in Florida. And then if that person also has, a mountain home up in, Georgia or North Carolina, and some other property up in New England and maybe some out west, every place that individual owns real property, they have to do another probate. And it's called an ancillary probate.
Okay, so basically what you were saying was that if the individual owns multiple properties in different states, then technically they have to go through probate in each individual state?
That is correct. So when you are having to do a probate, you have your regular Florida residence, you have your regular probate that you're doing in your state of residence, which is assuming you're Florida. And then for every other state where you own real property, you would have to do another probate, and that's called an ancillary probate. And that can get very expensive, as you can imagine, depending upon what each state's process is and how much attorneys charge in each of those states. It can really vary because some states their probate process is fairly easy and not really time intensive. And then other states, it's a lot more time intensive and expensive. So my recommendation, whenever somebody tells me they own property in other states, I always say, I recommend you get a trust.
Excellent, excellent. Now, again, each case is, vetted on an individual basis based on their assets, everything that's involved, how many siblings, you name it. But one item, that is relevant as well, especially as seniors are now living much, much longer, okay, You have what's called short-term memory loss. You have dementia. You have Alzheimer's, or someone can be in an accident and all of a sudden in a coma. How do you avoid issues like this where the spouse that is alive that can make decisions for you can actually take control over decisions that need to be made on your behalf?
Okay, so if speaking of the trust first, because we were first talking about that, most people will have both of the spouses as trustee. And then if one of the spouses either passes away or becomes incapacitated, the other spouse just continues business as usual on his or her own. If something happens to that spouse, then, a successor trustee takes over. With respect to health matters, we always recommend to have a healthcare surrogate. And a healthcare surrogate is somebody that you would choose to make healthcare decisions for you if you are unable to do so. And we always say most people will choose their spouse, but I always recommend you have a successful healthcare surrogate so that if your spouse is unable to serve in that capacity, you have somebody else who's able to serve. We include in our healthcare surrogate a living will. Most people that we speak to are very clear that they do not want to be hooked up to machines when they're at the end of their lives. So that living will gives the healthcare surrogate and the healthcare workers and facilities and doctors an understanding of what you are wanting and how you are wanting to be treated at the end of your life. And we also include HIPAA language in our healthcare surrogates so that not only can the healthcare surrogate make decisions, but can obtain those necessary healthcare information in order to make good decisions. In addition to the healthcare surrogate, we recommend a pre-need guardian. And what that is if you ever did become incapacitated and somebody filed a guardianship to have control of your property and your person, making decisions about you as an individual, you can choose now, while you have capacity, the person that you would want to serve as your guardian. And you can choose the same person to be guardian of the person and property, or you can choose different people. And we always recommend, again, backups in the event that the person that you choose is unable or unwilling to serve. And then the final document that we recommend in the event that you do become incapacitated is a durable power of attorney. And the durable power of attorney allows somebody to take care of your finances while you are unable to do so or just unwilling to do so. So with the power of attorney, it doesn't have to be that you're incapacitated. It could be that you've just become older and it's just too difficult for you to handle finances, and you want somebody else to take care of that for you. And again, most people will choose their spouse and then have other people serve as successors. Power of attorney is very, very powerful. And this is the one document that I have seen people abuse more frequently than any other document. So it's really, really important that you choose wisely who you want to serve in that capacity. And also make sure that you are, keeping track of where that document is. We keep originals at our office in our safe, but I tell people, put it in your safe deposit box if you have a safe at home, someplace where somebody can't gain access to it and start using it without actually having the authority to do so. So, the power of attorney, you have to really think very carefully about the person who is going to have that power.
Absolutely. Absolutely. And I guess things can get a little complicated, to say the least, if there's a divorce or there's, children from previous marriages. I guess things can get a little complicated when there's all sorts of siblings involved, correct?
Oh, yes. I mean, family dynamics, people think family law is tough because of the family dynamics and the emotions and the whole psychology, but when you're looking at estate planning, and then you get the stepchildren, and it can get pretty complicated in making sure that each spouse, their goals may not always align, especially if they have children from previous marriages. So it's really important to have those conversations with the spouses. And it's not uncommon for one attorney to represent a couple. That's very common. When I represent a married couple, I always have them sign a dual representation form stating it real clearly that, if I'm representing both of you, one of you can't come to me either at that time or down the road and tell me something that not to share with the other spouse. That would be a conflict. So I have to be looking at what's in both of the individual's best interests. So, when you're doing planning, particularly when you have stepchildren, it's really important. If there's going to be a conflict, then probably both parties needs to have separate counsel to be able to figure out what each individual wants as far as estate planning.
Excellent. And it sounds like, obviously the more assets, the more complicated things can be, and a huge difference between a will and a trust, and ways to avoid probate, etc. And the fact that you have 3 offices serving not only Flagler, East Volusia, and West Volusia, any individual that needs assistance in the state of Florida, you could really serve them, because like you said earlier, you can do phone calls now with all the new technology, Zoom, everything. A lot of things can be accomplished online or by phone, etc., where you can send them back all the documents, etc., and facilitate all the services that you offer. But at the same time, if they want to set up an appointment, they can actually go to these locations, correct?
That is correct. And I would be remiss if I did not say that I am able to serve all of the clients that I serve, because I have an incredible staff. I have 2 full-time paralegals, 2 legal assistants, and then I have a file clerk who has been with me. She was going to Father Lopez High School, and she's now a student at Embry-Riddle, hoping to get into the Air Force as an officer. So, I have a great staff, and they are very efficient at what they do, but also very, very friendly. And I think that's so important when you're talking about family, whether it's, doing the estate planning, guardianships, family law, all of those. It's really important to have a friendly face when you're dealing with issues that can be very difficult and very emotional.
Excellent. So for those listening in, we have great news, okay? Because all of our vendors go through a vetting process, and we stand behind our vendors, okay? And Mrs. Mara is willing to work with our seniors. She is offering a special that if you call 386-313-0113, again, 386-313-0113, and you mention that you found out about her through OurSeniors.net or OurSeniors.Radio.net, she will have a special offer for our seniors. And tell us a little bit about what that offer is.
Yes, so for those who call, and it's important for the callers to mention OurSeniors.net, that we will give a free half-hour consultation. The cost of a half-hour consultation is $150 typically. So, you get that free as long as you mention it, and we'll schedule you for a consultation. And that can be by phone now, but once things are back to normal, also can be in person if somebody wishes that.
That is great news, and that is greatly appreciated, Mrs. Mara, because folks, right there, you saved $150 for a half-hour consultation, and Mrs. Mara will, completely deal with you, transparent. And if you need help and you need certain documents, she'll tell you. If you don't need it, she'll tell you as well. Okay, so it is truly an opportunity for you to get all your ducks in a row. Again, you can reach Mrs. Mara at 386-313-0113. Don't forget to mention OurSeniors.net or OurSeniors.net. And on behalf of OurSeniors.net and OurSeniors.net magazine, thank you so much, Mrs. Mara, for joining us today. This has been very educational. There's so much to take on that we really need an expert like yourself to guide our seniors through this. Okay? Thank you again.
Well, it was my pleasure. Thank you.
All right, folks. Thank you so much.